Hello everyone, welcome to the Sweeney Show Business Law Podcast. My name is David Sweeney and joining me here today is Stuart Gilhooly, a solicitor of H.J. Ward and Co-Solicitors in Dublin. Stuart, you're very welcome.
Thank you very much, David.
So I was reading your bio recently. Your CV was online, I think, for one of your arbitration roles with the FAI. Wow, what a legal career you've had.
Yeah, it's been busy. I started off, I suppose, early from a representative point of view. I started off with the Law Society when I was very young. I was only 27 when I started there with them, and I've got to the stage where I'm really finished at this stage, and I'm only 50. But yeah, then I got involved with the SBA as well. So the two of those two are, they were huge for a long time. I mean, I'm still very much involved in the organisations, but yeah, it's been busy. That's
and
for sure.
You're a former president of the Law Society. Did you enjoy that year?
I did, but I found it very difficult. It was a busy year. It's difficult to run a practice and be president of the Law Society. I'm sure that probably seems obvious, but I tell you, it's like, I think some people, some presidents over the years have effectively taken the year off. I mean, I remember Barry Shields when he took it over. He was at LK Shields at the time. He was managing partner of LK Shields, but he literally took the entire year out.
Yeah,
and didn't do any practice. But when you're in a small firm like mine, and your clients want to see you, and they're not really that interested in whether you're president of the Law Society or not.
Yeah.
It's not really an option. So you find yourself just juggling everything.
Yeah.
But I did find it was certainly taught me a lot about what I needed to do and what I didn't need to do, and the work that I was doing that I didn't need to be doing that other people could be doing.
Yeah.
It taught me a lot about delegation. So yeah, the year, to answer your question, was a great year. It was something I'll never forget, and I look back on with great pride. But I wouldn't have done the second year.
Yeah,
sure.
And did you notice like your time management skills had changed? You learned how to manage your time more or be more efficient with it?
Yeah, definitely. I learned a lot about how to manage tasks in certain periods of time, and to make sure that you set aside a certain period of time to get something done, and to make sure you did get it done. The other way, we're all, I think, a bit guilty of, saying I'm going to do this and do that. But if it doesn't get done within that time period, probably most of the time you just go, well, look, it's not the end of the world, I'll do it tomorrow. Whereas during that time, everything was critical and you had to make sure it got done. Otherwise, Armageddon would have.
Yeah. How did you cope then, even in that year specifically, because obviously you have a very busy practice, you're a high-profile solicitor, renowned personal injury advocate, and then to add the Law Society on top of that, how did you manage all that, personally and professionally?
Yeah, I mean, that's a good question. I mean, it's just difficult. Again, it comes down to compartmentalizing and time management. It comes down to, making sure that you find time for everything. So you have a certain period that you'd have for your practice, a certain period of time for family, and a certain period of time that you have available for the Law Society. And you say, that's when I'm going to do these things, and I'm going to concentrate on those things just then. And the rest of the time, you just have to go with what you're doing. But it is doable.
Yeah.
But everything's doable.
Yeah.
People always say to me, I don't have time to this and I don't have time to that. You do have time.
Yeah.
Everybody can make time to do anything if they want to.
They prioritize.
It's just a question of whether you're prepared to do it.
So from the president of the Law Society, can I take you back then to how you trained? Did you go to you did an undergraduate in UCD, was it?
Yeah, so I did BCL and UCD, and then I did a diploma in business studies in the Michael Sparks School for a year.
Was law something in your family? Was that something, or was you passionate about it?
My dad was a senior counsel, so so he was very much a thing in my family. He kind of came to it late. He started when he was 35, so I witnessed the life of a child of a junior counsel for the first 10 years, and I can tell you, it put me off every bit of a barrister. It's tough life. I wouldn't recommend it to anyone. You have to be very disciplined. You have to ideally have a bit of, be younger and be able to handle life without money, because it's a tough life. So yeah, he was a junior at the time when I was growing up, and subsequently took Silk, and so I mean, I think I probably most likely from the time I'd hit my inter-cert, I was going to probably become a lawyer. I had this kind of idea that I would like to be a journalist as well at some point, and I always enjoyed writing, always enjoyed reading, and I suppose I still do a lot of that now, but I kind of managed to mix the two of them a bit, but but in the end, I think from the time I got to do my intercert as it was known then, I was probably going to be a lawyer.
And then, did you go straight from UCD into Blackhall? Did you experience any other
Yeah,
travel?
I did.
Pathway?
Yeah, so after doing the DBS, so I'll tell you how my interview with my then employer and my now consultant partner went. But in 1992, when I started, there was a recession. Effectively, it was the end of a recession before the last recession. If you know what I mean?
Yeah.
And there was very little in the way of jobs around. I remember interviewing for a couple of jobs in big firms, got absolutely nowhere. I don't even think I got a second interview. And ultimately, my dad said to his best friend, Harry Ward, he said, I remember exactly when the interview took place. It took place at the bar of a pub in Harris Cross. And it was something along the lines of, Stuart, we started with you on Monday. And that's how that went. So I did. I started with him on the Monday in October 1992, and I've been there ever since.
Wow.
Nearly 30 years ago.
Wow.
So it's so that was it. So I was an apprentice to Harry Ward. I qualified in '95, and then the rest is history. I'm still there.
Yeah. And so in that arc of 25, 26 years of qualification, what are the significant changes you've seen in the industry in Ireland, and in particular personal injuries?
Yeah, it's a lot. I suppose when I started in '95 as a qualified solicitor, you were still dealing with Payab hadn't been heard of. We knew what that was. You were still probably dealing with the fallout of juries haven't been abolished 7 years beforehand. Juries before my time, I wasn't around for the juries. But it was still very much the round hall, dominated everything at that stage. So what changed, I think, was 2002, the first insurance crisis, led by Dorothea Dowling. She was a tour de force. I mean, I don't know, some of the younger people watching this, and probably even yourself, don't remember much about that time in 2002.
Yeah, what do you mean by insurance crisis?
So there was a massive insurance crisis like there is now, that insurance was too high.
Okay.
So the government set up the Motor Insurance Advisory Board, led by Dorothea Dowling, who was a tour de force, extremely persuasive and articulate woman, who at the time was the claims manager of CIE, but she became very persuasive to government on how to handle the crisis, and the result of that was the setting of the Personal Injuries Assessment Board in 2004. So that was very much the last time around there was an insurance issue. The Payab came along. It temporarily did reduce insurance premiums, or whether it reduced it or whether they reduced anyway, who knows. But certainly the effect of it was the premiums went down for some time. And then, as always happens in all the cyclical world, the cyclical insurance world, the insurers decided they wanted to make more money again. So they put premiums up, and they blamed lawyers.
How was the Payab received in generally by the legal community when it was brought in?
Not well at all. I mean, I would have been one of the leading advocates against it at the time. I was very strongly against it. I mean, I think what people forget now, and particularly those maybe who weren't involved at the time, is that the Payab, to begin with, didn't want lawyers involved at all. It was described by its then Chief Executive, Tricia Byron, as a lawyer-free zone. And it was so for the first 2 years of its operation, operated this ridiculous system whereby clients could still come to solicitors, which they did, 90% still went to solicitors. But an application would be made by solicitors to the board, but they would not correspond with solicitors at all.
Okay.
So all the correspondence would go directly to the client, and they wouldn't acknowledge even, the existence of the solicitor at all. So it was a ridiculous situation, and it resulted in a case called O'Brien versus the Payab, which was brought in 2007, I think, or 2006 maybe. And the Law Society joined as amicus curiae to that case, and in an extraordinary case that went to the Supreme Court in the end, the Law Society had Dermot Gleeson advocating, and he produced one of the best performances I've ever seen in a courtroom. by explaining why, claimants had to have solicitors and why, it was just deeply unfair that they weren't. So ultimately, the High Court and then the Supreme Court decided that the Payab had to correspond with solicitors. So that created a real, distrust and dislike by solicitors towards the Payab. I think that, at the time, there would have been this view that solicitors were out to sabotage it by the Payab, and the Payab's view was they were out to try and look after insurance companies. And the distrust lasted for a number of years. But as time went on, people got on with it, and I think the real sea change was when the Supreme Court said, yeah, no, you have to correspond with solicitors. Yeah. And I think Payab then realised that was the only way it was going to work. Yeah. Everyone calmed down a bit, and I think now everyone worked well quite.
And as a mechanism, do you think it has worked?
I think it has, actually. I mean, it's worked in the sense that it has taken lower value cases out of the system. It has meant that they settled easier. Look, there's an argument that maybe there's a better system out there, and a colleague of mine said the other day, why has no other country in the world come up with this system if it's so good? Why are we the only one that does it? Which is a fair point. But whether I think it's a good idea or a bad idea, what is certain in my mind is it's here to stay. Yeah. I don't see any way that it won't. I think it's established. It's now very well run, and it seems to be wanting to get more powers than it currently has. The latest consultation process is suggesting that it wants to have more cases and not less.
And what does that mean then? Increasing the bands of cases that they might hear?
Yeah, so there's two things really. What they want to do is, one is Section 17, which is the section which allows them to release cases on the basis of, say, it's cases too complex for them to deal with, or an interaction with other injuries, etc. So that what they want to do is they want to have more of those cases in there, and they want a consultation process as to whether they should really keep some of those cases. So that's one area. Another area they want to do is they want to expand into the number of cases that get turned down. So a lot of insurance companies don't agree to assessment by Payab for liability reasons or minimal damage or any number of reasons. And they want to create a mediation service. They want to have the ability to mediate between the parties. And in fact, Rosalind Carroll's on record over the weekend as saying that she wants it to be the Personal Injuries Resolution Board, not Assessment Board. So, it remains to be seen how that pans out.
Okay.
I mean, I think that any mediation that takes place would have to be voluntary. I don't think you could have forced mediation. I don't think it works. I mean, that's effectively, Payab currently is a forced mediation system on paper, because only one of the parties gets to decide whether it's mediated or not. But, by creating, another layer where you're maybe one of the parties says, I want to have mediation liability case, I don't know if that's going to work. But look, ultimately they'll do whatever what they think is right. Certainly government have bought into Payab, they believe it works. They see it as a solution. It's got the support of the public, and most importantly, it's got the support of the business lobbies, and that's what gives it real kudos.
And is that then what's happened recently? More lobbying from businesses and the insurance industry would brought about these new guideline changes that are actually coming into effect this weekend?
Yeah, it's definitely made the biggest difference. The biggest factor has definitely been the business lobbies and how they've got involved, because they're seen as not having a skin in the game. They're seen as not being, self-interest in the same way that, solicitors are.
They're the business holders, the policy holders who are paying the premiums.
Yeah, well, they're seen as being neutral. Now, look, I have my views about some of them and how they operate, and I think that certainly they spend far too much time concentrating on victims of personal injury and not enough time concentrating on green insurance companies. I think people forget that insurance companies are the ones who actually set the premiums. All we do is as solicitors is do a job and get paid by other people who determine what our fees are. We don't even determine our own fees. So I think the abuse we get is completely wrong, totally unwarranted. But you'll never go wrong as a politician, or in media, or even as a member of the public, is slagging off solicitors, because everyone's happy to have a go at us. We're fair game.
I saw this thing on the internet, a memory the other day, that everyone is happy to slag off solicitors, but every parent would like their child to become a solicitor.
There's absolutely no doubt about that. There's no doubt about it. And also, the other thing is, people slag off solicitors as a profession, but will almost always say they like their own solicitor.
Yeah. Or
they'll say, "Oh, my solicitor's good. It's just the rest of them that are greedy robbers." And like it's boring, it's lazy, it's unnecessary, but it's just the way it is, and it's not just in this country. I know Ken Murphy used to tell me that when he went away to all the other countries, he spent a lot of time in other countries around the world, the bar associations around the world. I said exactly the same issues arise there. Like the public, government, media dislike lawyers. That's just the way it is, and it'll never change.
So the new guidelines are coming out. They were published recently for review, and then it's about 70, 80 pages of a document. So what is the most far-reaching in it? Is it purely a reduction in the amount of awards or the window of awards that will be assigned to certain types of injuries?
Yeah, I think so. I think that there's a number of big changes in it. One, it's certainly more granular than the Book of Quantum. There's a lot more detail, and there are a lot more injuries covered in it. So, for instance, you've got psychological injuries that were never covered before. You've got scarring, which was never covered before. There's a lot more detail. But I mean, the biggest effect is definitely going to be in the fact that so many injuries have fallen. And if you look at the lower level, the stuff that maybe is from, say, 10 to 30,000, that's sort of, or sorry, 0 to 30,000, those values have dropped probably 50%. As you go higher, the amounts don't drop as much. But there's a drop at pretty much every level except at the very highest level. And it reflects the views of the Court of Appeal, which is that moderate injuries should attract moderate compensation, and minor injuries should attract minor compensation, and serious injuries should get the big bucks. And that's that's also a view that's is seen, I think, in the public, and the public take the view that people who suffer really serious injuries should get substantial compensation, but they just do not like the idea of people with sore necks getting what they consider to be too much. But of course, a lot of that is ignorance. A lot of that is just assumption that if you've got whiplash injury, that you can't, that it doesn't affect you. And of course, in some cases, it's not serious, but in a lot of cases, it's very, very serious. And I've had clients sitting in my office crying and saying they'd do anything to go back to the day when they didn't have their accident, or the day before their accident they would, So it's different for different people, but I do think that there's a misunderstanding in the general public, and most people haven't had a whiplash. And if they have it, they might understand it better. But most people haven't had it, so they just don't understand it.
So the date that these new guidelines are coming in, I think, is this Saturday, 24th. And what they're saying is that if they will be go against any claim that's currently you either have to have your Payab assessment or authorization, or else you will apply the old rules apply. But anything before that is the new rules. So that means that potentially, because generally Payab say 9 months to assess a claim, but because of COVID and everything else, you could have lodged a claim say last January, February, and it's reasonable that it would still be in Payab now because of delays of independent medical reports through the Payab system and doctors and all that, which are reasonable. But now, because you've been in Payab for a year, but your assessment hasn't issued or authorization, but the new rules, the hammer is dropping this Saturday, your claim will be assessed in a completely different ambit. Is that correct?
Yeah, it is, yes. So I suppose there's a lot of people who are very, I think, understandably very, very annoyed about the fact that, it's a two-tier compensation route now. And that, if through no fault of your own, your claim has been stuck in Payab for a year. And I have a lot of claims in that category, so this affects me as much as it affects anyone. It's certainly very unfair. I do not think it's illegal, though.
What's the logic? Why did they pick that timeline? Why couldn't they say any claim, just either any accident after that date or any claim lodged in Payab after that date?
I'll tell you why I think they did that. It's a cost penalty issue. So if you have issued proceedings, then say in the High Court under the Book of Quantum rules, and the value of your case is now a circuit court case, you're going to have a cost penalty even if you try and remit that, or you get a cost penalty, or you get a penalty cost. So you can understand why they picked any proceedings issued. The other one they picked was Payab awards even where proceedings aren't issued, and that's because of Section 51A. Section 51A says that where you can't beat Payab award, or when you don't beat a Payab award in court, you cannot get your costs. So that's a strict provision, and there's no way around it. So if you turn down a Payab award before the new guidelines come in, you can't be punished for that, and that's wrong. So they're the two instances in which cost penalties will apply. No cost penalties actually apply for any cases still in the Payab. It just happens to be a different set of rules now. Okay. So a different set of guidelines. So you're unlucky, there's no doubt about that. But you're going to be unlucky at some point. I mean, as you said, if for instance, you said it only applies to actions that occurred after the 24th of April, that's fine, and that probably is the fairest way to do it. But you're lucky if it happens after the 25th of April. Why should that person be punished? But what about, I think that's the argument that we go against it.
So I've kind of two questions then for you. So what if then, which happens a lot, so say that example that I've just given there, that it was lodged in, say, Payab in February 2020, and say that accident occurred in, say, October 19. And then they came into the solicitor in December, and it was took instructions, started the process, and then, which often happens when you send out the initial letter, the insurance company gets it, they might approach you and try to make a quick offer. So what if, say, they've said to you, look, it's without prejudice, but we're happy to dismiss this, we can see where the injuries, say perhaps actually the accident was a bit before that, so say 8 months previous, so the client had 6 to 8 months of pain, reasonably recovered, and they valued the claim at, say, €14,000. And you says, look, it's probably a fair offer, but it's a reasonable offer, but I think your claim is worth more. I think you might have a further complication. Let's get a further medical report, or else let's just see what the injuries board might assess. And now what's happened now is new rules apply, no authorization is issued. What happens to that person and to that solicitor that has declined a 14,000 offer, and that claim may now be worth €1,500?
Yeah, I mean, it's grossly unfair, but I suppose the difficulty that you're going to face in terms of actually doing anything about it is it's a without prejudice offer.
Yeah.
And you can't refer to it in any court proceedings. So it's as if it didn't happen. So if you were to say, take a judicial review and say, look, I've suffered this loss, how are you going to articulate that loss? It's without prejudice. You can't refer to any court proceedings. Yeah. So I think that's jeopardy. That's the business we're in. And if you turn down an offer, some things can happen that will make you regret that. Yeah. So I don't think that's the case.
Yeah, and the second question I have is more a business decision from a solicitor's point of view, because solicitor practice or commercial enterprises. So say that in that claim, or that example of claim and of the original value, the solicitor would have made a risk assessment, made a decision to take on the claim, a stateable case, and then invested off his resources to take that claim from the beginning and support it, go all the way through, whether it's the solicitor, exec, secretary, service, all that kind of stuff. And now, when they've got to the point where this case is now concluded, the potential legal fee has been obviously hugely reduced.
Yeah, and that unfortunately qualifies in the category of tough shit. It's a gamble we take. Yeah, I mean, that's how I operate my business, and that's going to affect my business as much as anybody's, and I'm deeply unhappy about it. But I don't see what we can do about it. Like we the way it operates is it's not our money, it's the client's money, and if the client, ultimately, if we've decided to make a business decision to invest in this business, I suppose you could call it,
that's a business risk.
Then if the rules change, then that's our tough shit, isn't it?
Yeah. Okay. And have you seen this thing recently? And just happened. I've seen 2 incidents online, quite similar in the last 3 weeks, where one large organisation in Ireland, a takeaway company, fast food organisation, published letters that they received in, and they're the standard initial warning letter you'd send out. And then I've seen another restaurant owner in Dublin, he's an influencer on Instagram, and it's kind of, are they kind of riding the wave of the public opinion that we spoke of earlier against solicitors? Or obviously we don't know the facts of the individual cases, and if the solicitor's taken on, they hopefully are genuine cases and there's merit in them. What's your view on that, I suppose?
Well, I mean, look, what the two of those people did is totally wrong, utterly wrong. I mean, just so to be clear, I mean, we're talking about Supermax is the first one, and I mean, I've dealt with Pat McDonough for years. Again, McDonough was around at the start of the 2002 crisis, so he's been around a long time. He's made a lot of noise, and the man has no filter at all. and he's prepared to say pretty much anything.
So is it a form of advertising for him?
No, I actually don't think it is. Okay. It might be, but I don't think that's his reason. I think his reason is, look, I hate solicitors, I hate claims, and I want to expose them. And okay. he works on the basis that it's all a fraud, or they're all frauds. I mean, it's obviously bullshit, but that's what he thinks. And what he did to that solicitor's firm is appalling. I think he should be called out for it. I think he should be sued for it personally. But I think that's McDonald. Like I can't believe he's still taken seriously. Is all I say.
He's self-insured, is he? Supermax. Are they self-insured, Supermax?
They are, yeah. Yeah, and look, he got a bit of notoriety years ago because he managed to expose a fraud in his in Supermax.
CCTV,
I think it was a camera in a toilet, wasn't it?
Yeah.
And ever since then, he works the basis everything's a fraud, which is just simply not right. But the other situation, those other people, I think that was an advertising thing.
Okay.
I think they're very good at that sort of stuff. They're very they're very focused in making kind of Eamon Dunphy type statements that get them a bit of publicity. Yeah. So I think there was an element of that to it. But again, I'd imagine that particular photograph will appear in a court case at some point, and I don't think it'll help them.
Yeah.
So
do you so just going back to the new guidelines, is there anything a solicitor can practically do right now if they have claims in their office that are not lodged in Payab, or they're waiting for, or the Injuries Board are waiting for medical reports? Is this going to happen? Do you think any change of mind or any judicial review or anything of the date for any of those claims that are in Payab for nearly a year or longer, are either claims that solicitors have recently took instruction on but have not yet been lodged? Is there anything a solicitor can do?
Not really. I mean, look, you could certainly take the conservative view and say that if somebody ever did challenge that process whereby the guidelines apply to cases in Payab and successfully did so, you could put your case into Payab now even without your medical report and make an argument that your case that your case would apply to those guidelines or the book quantum if that ever happened. But my guess is I don't think anyone will ever take the case on. And I'll tell you why I don't think anyone will take a case on. I think it's because anybody who took such a case on would be a mark. And because they have compensation, they get an award. So even if they don't like the amount of the award, they'll still get an award. So if you take on a case, say having got 10 grand from the Payab, which you say would have been worth 20 grand on their book of quantum money, if you take a case to the High Court challenging that, you're going to lose that 10 grand if you lose your costs. I don't think anyone's going to take that chance, particularly for what I think would be a speculative case. So look, the short answer, David, is I don't think there's much you can do.
Yeah, there's some practitioners in Cork here have said that they have been writing to the Injuries Board requesting the authorization or the assessment this week.
Yeah, and I know they have done that. And in fact, I don't know whether you saw the law society's easing last week. And there's a letter from Rosalind Carroll of the Payab in that, in which she more or less said, stop writing to us.
Okay.
We'll do it at our normal pace, and we're not going to do any quicker just because you asked us.
Yeah.
That's the gist of what she said.
Okay.
So yeah, I mean, look, there's no harm in asking. I have found myself that there's been a lot of authorizations that come out in the last couple of weeks. I think it's a coincidence, but I've almost got to the point where I don't want to see anymore, because if I see them, I'm going to have to issue the proceedings. It's getting close to the.
And how have you find the attitude? Yeah, and just on a practical level, not related to the guidelines, but just in relation to dealing with insurance companies for possible settlement discussions over the last 12 months since COVID.
Yeah, I found them okay. I tell you what I have found. I found, number one, they are willing to engage in a lot of cases, but I found it painfully slow.
Yeah.
Like in the old days, you'd set up a settlement meeting and you'd have a meeting in the law library in Dublin or wherever people do it. Usually in a court setting somewhere, and you'd set a meeting for 1 o'clock or whatever, and settle by 2 or half 2, and that'd be the end of it, or it wouldn't.
Yeah.
I have found now, you're doing these settlements by briefing counsel, and they're ringing investors, trying to ring an insurance company. And it's taken weeks and sometimes months to get the case set.
Yeah.
And sometimes you don't get a response at all.
Yeah.
So I do find it very frustrating. It's definitely not the same as it used to be. I do think we need the courts operating again soon.
Yeah.
I think it's the only way the system operates properly. And
if
but look, at least some business is getting done.
Yeah, because you're missing that leverage of at least an impending court date if all the pleadings are ready and there's a notice of trial and your trial is.
And you definitely need that, and you also need. I also think you're much better off having the personal touch of the client being there with you.
Yeah, and explaining with the
barrister being there if there's one involved.
Yeah,
and you know, having that feeling of an event, of it being taken seriously.
Yeah,
I mean, instead of phoning somebody up and saying I have an offer for you, or doing a Zoom call, which just isn't the same.
Yeah.
So look, with a bit of luck, by October we'll see courts open properly again. I have a feeling we will. And
how long do you think it's going to practically take to catch up with the backlog?
Yeah, I mean, there's a story in the end of the day that they're going to appoint 5 High Court judges to catch up with the backlog. I love the way it's always the High Court that gets the extra judges.
Surely that will trickle down, though, won't it? Especially with the new guidelines, new district court judges.
Well, it is. That's the thing. And I don't think they've seen this. I think certainly the circuit of district court, particularly the circuit court, are completely under-resourced. And the difficulty is that there's no infrastructure for them. There's no courtrooms. There's no staff. So it's not just judges. It's staff and courtrooms as well that's required. So I do think in the next year or two, you're going to see that. I mean, the circuit court in Dublin is a mess. You can't get cases on. It's getting them on at last. But like the delays are.
Is that just because they're just overwhelmed with volume, is it?
Yeah, it is. And it's no one's fault.
Yeah.
It's just the way it's gone.
Yeah.
But like it's I'm sure it's the same in circuit courts around the country, but it's particularly bad in Dublin, I think, with, I mean, you're getting, for a start, you can't get any court dates for anything that's been set down because they're waiting to see, what's going to be open when, and they're trying to deal with the backlog. But I suspect that when court dates come out again, you'll be looking at next year. But I remember a time when that was the norm.
Yeah.
Again, this is going way back, but in 1998, there was a Judge Harvey Kenny came in, and he took hold of the backlog of the Dublin Circuit Court, which at that stage was about 2 years, 3 years, I think it was. And he grabbed hold of that, and he got rid of it by having call-overs and forcing people on. And I think something like that's going to have to happen again. Somebody's going to have to grab hold of this and say, this business of people waiting for a year and a half or 2 years for the cases, it can't happen. Just can't.
Stuart, thank you so much for your time. That's been a fantastic episode. I think any personal injury lawyer or even a trainee solicitor in Ireland is going to find this massively interesting and helpful. Thank you again, and I sincerely wish you all the very best for the future.
Yeah, no problem, David.